Hi, welcome back to Finally Revealed. In this episode, I want to talk about a topic that was raised by a viewer question, and it involves exempt property. In the United States, we have property that is considered exempt under the individual state laws. And what this means is this is property that no one can take away from you to satisfy a judgment, with the understanding that the property is free and clear. In other words, you own it without any liens against it that you have entered into in connection with the purchase of the thing, and to finance the purchase of the thing. So it's really important to first understand, when you buy a house and you get a mortgage, that there's a lien on the property until you have paid that loan off. That company, that if you stop paying them, can come and take the property away from you and sell it. And that applies no matter whether the property is in an exempt category or not. That is called a consensual lien. So if you have a car, for example, that is paid for, and in your state $5,000 of a car is exempt property, and your car is worth $5,000 or less, no one can take that away from you because it is exempt property. The question that was posed to me was, if I have an asset that is exempt and I go to sell it, how do I keep the money from that asset protected? And the answer was longer than I could put in a comment, so I said I would do a video. So I hope that this will help you understand the process. This comes into play in two major areas. One is when you have someone who has a judgment against you, who is trying to enforce that judgment, and they are looking for property, earnings, and assets to take, to sell, or liquidate, and apply on that judgment. The other way it comes into play is in a bankruptcy. There are federal bankruptcy exemptions, and there are state property laws on exemptions. Certain states will allow you to choose the state exemption or the federal bankruptcy exemptions, and others won't let you choose. They tell you which one you will use. Depending upon where you live, the exemptions are different if you're dealing with a creditor versus if you are in bankruptcy. So if you are going into bankruptcy and you have a question about exemptions, please talk to your attorney about where you are living and which ones apply. So that having been said, when you have an asset that is free and clear, for example, you have a car, and your state exemptions say it is $20,000, and every person has the right in that state to have a car worth $20,000 and no one can take it away from them. For it to be exempt, it has to be $20,000 worth of equity. So if you have a $40,000 car and you owe $20,000 on it, you have $20,000 in equity, you get to keep that. Okay, so another creditor can't come in and take your car. If you have a $20,000 exemption for a car and your car is paid for and it's worth $20,000 or less, no one can take it away from you. Now, in order to maintain the exemption for that car, say you have a $20,000 allotment under your state law, your car is worth $15,000. You have a creditor who has been sniffing around and trying to find assets of yours and has been aggressive in bringing you into court and asking you questions and sending out garnishments, and you want to make some changes in your life and you want to get the money out of that exempt asset. Can you put the money in the bank and say it came from the car and the creditor has to keep their hands off? The answer there is no. Once the property is no longer in that category, for example, a car, and now you have cash money in a bank account or a CD or or you use the money to buy other things that are not exempt, it's not the car anymore. So to maintain the exempt status for the individual items or categories of property, it has to be in that type of property within those value limitations to be protected. You can sell an exempt asset and take the proceeds and put them into another category that is also exempt. For example, if you had a car and it was a $20,000 exemption, your car is worth $20,000 or less, you sell that car and you have the money from the sale go partly into your bank account and then partly into another car or partly into your house or another exempt asset that went from one exempt asset into another, and the only thing that would be subject to a creditor coming to take would be cash into your bank account. So this is a different type of a concept for most people to understand, but the exemption is not over the dollar amount, it's over the thing. So if it's a car or a house and you want to sell it, to keep it protected, it needs to be selling it for the money to go directly into another exempt asset. If there's any stop along the way and it's going to be money in the bank, you're not going to be able to protect it, and you need to get help to make those arrangements. It's going to be subject to being taken if that creditor finds that bank account, knows about the transaction, and sends a garnishment over. If you are selling a car to then buy another car, that's going to maintain the exemption, and you should be protected. I hope this was clear. If it wasn't, please leave any comments or questions below. Give me a thumbs up if this helps you understand the concept. Subscribe to see the other videos. Share this with someone who may be telling you what they are planning to do and you are worried about them. If this would help them, please share it. And come back and see me next time. Thanks for watching.